stated, we have salt in our blood, in our sweat, in our tears. We are tied to the ocean. The oceans are the common heritage of mankind, and international law is the tool we use to manage and protect this shared resource. A very good afternoon, everyone present here. Respected Chairman K.C. Ramamurthy, Dean Professor Dr. T.R. Subramanya, Director Dr. Vijay Praneshwaran, all
Yeah.
the faculty members of CMR University School of
Pleasure.
Human Studies, and dear students. I, Maria Tattil, a fourth year student of BBA LLB, on behalf of CMR University School of Legal Studies, welcome you all to yet another engaging session on the protection of people at sea in international law. We are honored to have with us today a highly regarded senior advocate and experienced professor of law, Mr. Mohan Katarki, a distinguished legal luminary and a senior advocate designated by the Supreme Court of India. He also serves as an honorary visiting professor of law at Bangalore University's Law College and as a professor of practice at CMI University School of Legal Studies. Mr. Katarki is renowned for his profound expertise in transboundary water law, specializing in the equitable sharing of federal and international river water resources. He has represented several states in pivotal cases before the Supreme Court of India and interstate water dispute tribunals, including those concerning the Kaveri, Krishna, Ravi, and Mahadayi rivers. Currently, he represents Karnataka, Odisha, and the National Capital Territory of Delhi. As an accomplished scholar, Mr. Katarki has published numerous papers on transboundary water law and constitutional matters, sharing his insights at national and international conferences and seminars. He has furthermore made significant contributions to legal education, serving as a member of the Academic Council at the National Law School of India University, Bangalore. And Mr. Katarki is also the Vice President of the Bar Association of India and plays essential roles in Karnataka State Law University's Board of Management and Planning, as well as KSLU's Student Law Review and Bangalore University's Law College Journal. We are honored to have with you, sir, in today's seminar that is most relevant than ever. Please join me in extending a warm welcome to Senior Advocate Mohan Katarki. Sir, the dice is yours.
Thank you. May I begin?
Yeah. Yes.
Yeah. At the outset, may I thank the CMR Law School for requesting me to speak on the topic of international law relating to sea. The law of sea, as we know, is a vast subject, but there are certain areas which require an immediate attention and which are of concern to the people than to the state. We all know people don't live on sea. They live on the land. But sea is intrinsically linked to the land. People come in contact with sea in their various activities. They become seafarers, military personnel, security personnel, fishermen, migrants, refugees, etc. The magnitude of the connection to the sea is less known than actually it is. This is why generally it is considered to be a neglected area. Sea is a common heritage of mankind. It is res communis. Nobody really owns the sea, but everyone has a stake or interest in the sea. No state has a legal ownership over what constitutes a common heritage. Quantitatively, sea water is about 97.5% of the total water on the earth. It covers approximately 71% of the Earth's surface. That means the remaining 29% is the only portion which is covered by the land. The major seas or oceans are Atlantic Ocean, Pacific Ocean, and Indian Ocean. From the earliest times, people have been using sea for fishing and transportation. With the advent of modern mariner compass in the 13th century, and after understanding the behavior of storms, that the law of storms coming into more systematic study, the sailing on the sea became easier and more predictable. The steam engine in the 17th century revolutionized the sailing. The digging of Suez Canal in the 1850s cut short the route to Asia from Europe by half. Similarly, the construction of Panama Canal changed the navigation to the west coast of United States of America. Great Britain, Portugal, and Spain emerged as sea powers in the 18th century. The success of British Empire was founded on its superior sailing techniques adapted to the military and traders. Today, the merchant ships alone are about 50,000 in the world. Some are as big as island, with facilities for landing aircraft or launching missiles. The international law of sea concerning the rights and obligations of the states in the interest of the people has its origin in the 17th century. Hugo Grotius, as you all know, the father of public international law, wrote Mare Liberum, that is freedom of seas, based on 2 centuries of state practices, juristic writings, and judicial precedents. The law of sea was codified under UN Convention of Law of Sea in 1982. We call it UNCLOS. It is broadly founded on three principles: freedom of sea, sovereignty of the states, and common heritage of mankind. The entire convention reflects these three principles. The prominent principle, of course, is the sovereignty of the states, because in international law, if you really ask me, this is the most basic rule and on which everything evolves, that is, states are sovereign. Nothing can be done. You cannot impose anything on the states. Therefore, the international law has to evolve keeping in mind the freedom of sovereignty of the states. Outside the UN Convention, several conventions address the protection of people at sea by defining their rights and obligations. Rights of people is a new area in international law in any case. In law of sea, it is a much neglected subject. Therefore, a special attention on the protection of people at sea has become necessary. Today, we have several conventions which address on the rights of people at sea. These are International Convention on the Protection of Rights of Migrant Workers and Members of their Families of 2003, the Maritime Labor Convention of 2006, the Fishing Convention of 2007, and the Safety of Life at Sea of 2012. These are few of the conventions, but there are many more conventions which address on the rights of people specifically at sea. Professor Irini Papanikokolu rightly says there is no dedicated bill of rights for people at sea. There is no dedicated bill of rights for people at sea. Makes us think that the world community, the international community, should move towards proclaiming such rights as early as possible. Hope the day is not far off when there will be bill of rights for the people at sea. How can international community protect the people at sea? Within the existing legal framework, there are two ways in which people are protected at sea. These are by exercising national jurisdiction beyond the territorial sea to redress the grievances of wrong persons. Secondly, by undertaking the state responsibility to prevent harm to the people. The existing law, that is existing international law of sea, does not provide for the exercise of national jurisdiction of a state beyond the territorial sea. This is well clarified in Article 89 of the UN Convention. A state has no territorial jurisdiction, but it has some sovereign rights over the contiguous zone, exclusive economic zone, and the high seas. But territorial sovereignty does not extend to these areas. Territorial sovereignty of a state is confined to the territorial waters or territorial sea. If international trade and tourism are to progress in the era of globalization, an active policing and regulation of the high seas by the international community becomes necessary. At present, it is only the flag state that has territorial jurisdiction to punish the offenders who offend the sailors of the flag state. But beyond that, the international law does not play any role in either policing or protecting people at the sea. When you talk of state responsibility, the extension of this principle on the high sea is important. Several questions arise that are of concern to the human rights jurisprudence. These are the right to be rescued, the right to safe harbor, and the right to temporary asylum on reaching the coast. I'm just mentioning some of them, which appeal to us immediately. The right to be rescued on the high seas has achieved importance with the growing migration of people. The innocent migrants are abandoned on the high sea whenever the law enforcement authorities detect or try to catch the illegal immigrants. The humanitarian state practices support the right to be rescued by such migrants, irrespective of the fact whether they are legal or illegal immigrants. We can't leave people in the high sea dying. We can't leave them. So the state, whichever is aware about the migrants, has to come to the rescue. The rescued migrants are entitled to the right to temporary asylum on reaching the coast. Until they are deported to their country, they have a right to be treated fairly, right to be provided food, and right to be protected in the territory where they land. There is a demand to convert this right, which is presently more a discretion of the state, to an affirmative duty, to a state responsibility. If the state fails to obeys the responsibility or the obligation cast on it, then international community should have the right to step in and impose sanctions. But unfortunately, this concept of affirmative duty has not still been accepted by the international community. It remains still a discretion of the state in providing humanitarian assistance to the migrants who are caught in the mid sea or who land on the coast by mistake or due to the ship wreckage or whatever the reasons. There is also a demand that the international community should respond and establish a institution. Institutional framework must come into picture, which will not only provide an independent force to rescue the migrants, but also protect the states which rescue by compensating them for their act of kindness. The states must be obligated to impose a posted duty on its ships that carry its flag to provide immediate help and rescue the lives of persons in distress at sea. When you see some ship in trouble, it is the duty of another ship in the nearby which gets information to go to the rescue of the other ship because the life of people is important. We have seen how signals of the Titanic were ignored by the nearby passing ship. Way back in 1911, when tragedy occurred, there is a information that the world believes that a ship which was in the nearby, though it got the signal, it ignored and just went away. And by the time the second ship came into picture with all grace, the Titanic had sunk, taking away hundreds of lives. Therefore, since the tragedy of Titanic, there has been a growing demand for the flagship to impose a duty on the flagship by the state to provide humanitarian assistance and go to the rescue of some other ship which is in trouble. But this issue needs to be addressed in a more comprehensive manner because the ship which goes to the rescue has to incur enormous cost in rescuing and abandoning its journey. Therefore, all these matters require an urgent attention and compensation to be paid for the ship which renders its helping hand. Since the Titanic tragedy, this issue has been extensively debated, but so far there is no institutional response on the question of rescuing people in the high seas. Hope soon there will be an institutional structure in international law to rescue the people on the high sea who are in distress. The protection of seamen and crew from pirates is another serious issue. In the last 2 decades, nearly 5,000 people have fallen prey to the pirates' attacks. Security Council has passed more than a dozen resolutions in this regard. Somalian pirates have been attacking the ship near the Red Sea, Gulf of Aden, and African Horn, which is a critical area of international trade connecting to the Suez Canal. Nearly 20% of the trade in the world passes through this critical area. Therefore, in this area, Somalia and its people have been taking advantage and attacking the ships and the crew on the ship. Recently, the Biden administration has approved sale of drones, etc., to India to the extent of nearly 4 billion rupees, 4 billion US dollars. The cost is high, but such a system of surveillance is necessary to protect Indian ships from the piratic attack. We also seen recently some pirates were caught by the Indian Navy commandos and they have been brought to India to put on trial. This kind of active policing really helps in protecting the people, in instilling the confidence in the people to act as seamen and seafarers. We all hope that the international community will pay more attention to the protection of people at sea. The protection of people at sea is intrinsically linked to the trade and fishing. Fishing is one thing which is most important. Large section of people in the world depend on fish as a staple food. The fishermen undertake hazardous jobs. Their rights, working conditions ought to be regulated. Sometimes the natural hazards take the fishermen on the wrong direction. They get lost in the deep sea. For that, rescue operations become necessary. Sometimes they might land in the enemy state. Many of the Indian fishermen are caught by the Pakistani forces, and many of the Pakistani fishermen are caught by the Indian forces. And whenever such things happen, there has to be a system to identify genuine fishermen and deport them back to their country. But what we see is in both the countries, the system is such that some of them have been languishing in jail for decades on suspicion of having entered the Indian territory or Indians entering Pakistan territory that as spies. Therefore, this is the area on which bilateral understanding between India and Pakistan is necessary. Similarly, bilateral understanding in various other countries is also necessary. If fishing activities have to be promoted, if fishing is to be an economical activity, then active intervention of the international community is very essential. Similarly, the laborers who work on the platforms in the high seas, particularly in the oil drilling, need to be protected. And their protection, if not given, it has an adverse impact on the production of oil, which is an important economic resource. But all this requires a concerted thinking in the international community. International law does help in promoting a just policy, but ultimately, what is the just policy and what should the international community do is a matter of for the international community to decide, which is a subject matter of international diplomacy. We all hope that international community, the diplomatic people will rise to the occasion and work towards a comprehensive treaty on protection of people at sea by proclaiming Bill of Rights for the people at sea. With this, I wish to close my lecture. I thank you all for joining this lecture. And if you have any questions, certainly I'm open to answer to them. Thank you, sir.
Thank you, sir, for tabling your expertise and knowledge. We now move on to the question and answer session. The attendees may unmute themselves and put forth their queries.
Mohan Katarki,
Yeah,
I have a small doubt. In the recent past, a subject is being developed by scholars, and this subject is international labor law of the sea.
yes, sir.
And in international labor law of the sea, they most of them make a mention of the international conventions. But a few of them, because of their employment, are not made applicable. So they are recruited from different sources, from different countries, and the regulating authority may be somewhere in some Latin American country. So, in such a situation, what would be the solution?
Yes, sir. This is a very difficult area because this is mixed with the migration policy. Lot of people from the poor countries migrate to the better areas in Europe and America, and these people, when they enter the country, they can some of them enter as illegal immigrants, and they start working. When they start working, they are not entitled to any of the protection of labor laws, which usually apply to the legal immigrants, and as such, they suffer a lot. Secondly, even for the legal immigrants, they are not treated on par with the nationals. The foreigners are always considered with discrimination. The kind of treatment which the nationals get, they do not get. There are certain restrictions with regard to the payment of compensation, etc. Therefore, on this area, a more responsible approach is necessary. So far, the International Labour Organization has been able to draft several conventions and get them ratified, but still, these things are considered to be a soft law. They are not received a higher attention as the security issues received from the Security Council. On matters of security, Security Council intervenes. But in matters of labor laws and environmental protections, all other issues which are not connected to the security, the enforcement of international law is very, very weak. Therefore, what is required is a strong enforcing agency and also an international adjudicatory body which can issue binding decrees on the states if the states are found to be violating the laws, or if the states are found to be not enacting the required laws to govern the conduct of employers. That's how I look at it.
Thank you. Thank you.
The public international law is still to pick up, sir.
No, still to become.
When you taught us public international law 40 years back, 43 years back,
Yeah.
I still remember every people used to say, what is the use of international law? And but still, some of us took interest in international law, but it is still yet to catch up. In fact, in some colleges, it is not even compulsory nowadays. It is an optional subject. And that's why I thought I should not take a long time and give a long lecture, because unless you crystallize it into a short one, the attention span of the student is also small.
Yeah, yeah,
To generate interest, it is better to compress it into less than 30 minutes. That's how I planned it.
yeah. No, it's fine. It's fine.
Yeah.
Because more than 1 hour means they lose concentration.
Yeah, these are not like a constitutional issues or other issues where one can speak for an hour or more.
Right.
Even these are the difficult issues, and unless a person is really interested in the subject of international relations, will not be able to appreciate or catch it. But still, there is a lot of appreciation and interest of the younger generation
Right.
in international law.
Now, I have a small query.
Yes, sir.
Now, all through as regards the international peace situation, we are not in a position to establish stability. We means the United Nations.
Yeah,
And every time when the international peace situation comes, there are states who will go to the extent of pointing out we will use the nuclear weapon. And and some of them on day-to-day basis they flout. If it is favorable to them, they support. If it is not favorable to them, they oppose. Now, what is the answer?
yeah, you're right, sir. This is a very serious issue that international community, the main concern is the security.
Right.
In fact, one of the famous saying is that the object of international law is not justice; it is to ensure peace. If that is the thing, then peace is the concern. We must, at any cost, ensure peace. But what we have been seeing in the recent past is the peace is in real peril. We have seen what happened in Ukraine, where a sovereign nation was openly attacked by Russia on a uh, flimsy ground. Then we are also seeing the excessive reaction of Israel over the people in Gaza. That has also resulted in or threatened the peace in the world. As a result, some countries which are sympathetic to the cause of Palestinians are hitting back at Israel. So all these things has led to a situation where the peace is, people feel the peace is likely to be threatened, and we are heading for a third world war. Maybe it is difficult in the present situation to reach that stage, because there are so many checks and balances. Even in the Gaza issue, also, the despite all saying Israel doesn't have free hand, the International Court of Justice intervened twice. It has passed some orders. One may say that it doesn't have much effect, but certainly it has a lot of persuasive effect. It has been a, a platform for building up the broad consensus in the world against the excessive use of force by Israel in Gaza. But still, the peace is not safe. We have to really struggle to ensure peace in this world, because there are many nations which are so powerful that they're so trigger happy. A small indiscretion might cost us badly. We might see some kind of a holocaust or something, and we're all really, really worried about these things. Hope good sense will prevail, but this is a matter on which there's still international community, international law are not able to grapple with.
So we have a question from one of the attendees. It goes, in case of piracy, how can one determine jurisdiction and who has the duty to protect international shipping lanes?
See, in the high seas, in the freedom of seas, okay, all states have the freedom to move around. There's a complete, you can say, democracy in the high sea. But flagship has the jurisdiction to catch the pirates and try them. Recently, India has been able to catch pirates in the Somalia area. the Somalian pirates have been caught and they have been brought to India for justice. This is one of the important case which India is going to see soon. The result of it, to what extent we'll be able to deal with that, because all said and done, the Somalian government will try to pressurize the government of India to secure their return. So these things will happen, but if you strictly speak in law, the flag state which has been attacked has the jurisdiction to catch the pirates or use such force necessary to repel the piratic attack and bring them to the country, put them on trial for justice.
So my
Yeah,
name is Manisha. I am from BA LLB fourth semester. So
Louder.
I wanted to ask about what happens about the cleanliness of the ocean. Like when any foreign ship comes, when they are carrying any perishable goods, if sometimes they get spoiled because of any problem to the ship, so they have to unload all that wasted ones into the ocean. Like they have to throw it into the ocean. So if it is under the jurisdiction of any other country, what about the cleanliness of that particular ocean? Like,
yeah. This environmental concerns have been a matter of serious issues. If the uh, environment is violated or if the environment is damaged within the territorial waters, naturally the nation, the coastal state, which has territorial jurisdiction, takes action. It enforces its environmental laws. But if it happens beyond the territorial waters in the contiguous zone, exclusive economic zone, the legal structure is not that sound, and there the matters are really at large. That the area where usually lot of degradation of environment take place. The harm to the environment in this area remains very weakly regulated. This weak regulation is being taken advantage by the ships by dumping the uh, waste food or all kind of things. In fact, I recently read that so much of plastic is found in the Aegean Sea that all that if it is collected, it can form by itself an island. So much of it is there. People, because a lot of cruise ships move around in the Aegean Sea, in that Mediterranean area, Greece, Turkey, Egypt, Italy, Montenegro, and it's quite possible that all those cruises uh, have not been strictly following the environmental laws and dumping the environmental waste into the sea. Therefore, this area again requires to be addressed by the international community more aggressively. The reason, as I said, it falls beyond the territorial waters. And if it is beyond the territorial waters, the coastal state cannot by itself pass the law and take any action in the high seas. And therefore, a collective action of the international community, either the United Nations agency dealing with the environment or bilateral agreements, have to be entered where the offending ships are brought to justice in some manner, either by imposing hefty fines or, if necessary, by prosecuting them and putting them in jail.
As
Right.
we now come to the end of the session, I am honored to deliver the vote of thanks on this memorable occasion. I, Maria Tatil, on behalf of CMR University, School of Legal Studies, and the entire fraternity of the Institute, extend my sincere and heartfelt vote of thanks to our chief guest, Senior Advocate Mr. Mohan Katarki, Supreme Court of India, who spent his busiest of time in gracing the occasion. We have had the opportunity to hear your thoughts, and this is definitely encouraging us in our future endeavors. I am also grateful to our respected chairman, K.C. Ramamurthy, for gracing us with his presence today. Our Dean Sir, Professor Dr. T.R. Subramanya, for his able guidance, which has always encouraged us. I thank him for his interest and kindness and hospitality and the continued support. I thank our well wisher, Professor Dr. Vijay Praneshwaran, Director, for his stewardship, support, and vision and commitment, without which this is impossible. My heartfelt thanks and gratitude goes out to our faculty coordinator, Ms. Nirmala Harish, for her valuable contribution, guidance, and encouragement in all our efforts. I thank all the distinguished invitees who are present here for accepting our invitation. And last, I would thank all the students for your cooperation in making this event a resounding success. As we draw close, I am reminded of the powerful words of Martin Luther King, who once said, "Injustice anywhere is a threat to justice everywhere." Together, let us stand against injustice and uphold the principles of fairness and equality. And let this be our byword. Thank you, everyone. Have a great day ahead.
Thank you.
Thank you.
Thank
Thank you
you.
very much.